investor-state dispute settlement system. This is a shadow legal system whereby multinational corporations can sue states for enacting policies they don't like, which infringe on their quote-unquote investor rights. And it happens all over the world. This system is enshrined in free trade agreements, which are a bit of a misnomer because free trade agreement makes you think it's all about mutual lowering of tariffs. But actually, embedded in these trade agreements are huge amounts of legal mechanisms whereby corporations can enforce their will on the countries that are part of that agreement. One of these is the ISDS system. So NAFTA has ISDS provisions in it, plenty of other free trade agreements.
So when the EU makes a trade agreement with a country in sub-Saharan Africa, it has ISDS in it?
Exactly. And there's the other part of this is what are called bilateral investment treaties or BITs. And they're all over the world. They're between two countries. And they just sort of, they're a regime, an investment regime that both countries have to abide by. But ISDS is enshrined in nearly all of those. So, and is enforced. So in the case of a corporation that wants to use a BIT, for example, you can just create a shell company in a country that has a BIT with the country you want to sue and just sue them that way. That happens all the time. So there's this whole web of treaties, agreements, which enshrine this ISDS system. And what it means, effectively, away from all the acronyms, all the boring stuff, is that corporations can sue some of the poorest countries in the world for huge amounts of money, billions of dollars often, for enacting policies like not allowing the company an environmental permit to dig for gold, for example. That was one case we looked at in El Salvador. There was one case in Egypt where a French water company sued the Egyptian government for raising the minimum wage. So anything that a corporation doesn't like that a government does, they can potentially sue for. Now, you would think that that is a massive attack on democracy, and it is. Because the second part of it is, it's not just the cases that get to court. Now, most of these cases are heard at a place called the International Center for the Settlement of Investment Disputes, ICSID, which is a part of the World Bank. The International Center for the Settlement of Investment Disputes,
right.
ICSID. It's an arm of the World Bank. It was created in 1966 at the height of what I'm talking about, at the height of decolonization and newly independent governments. And what it is the main venue where these cases are heard. It's also a kangaroo court. There's so much to get out on this stuff, but it's also a kangaroo court because these decisions are made by 3 arbitrators, one appointed by the company, one appointed by the government, and one agreed on by both. And it's hugely secretive. A lot of the documents you can't get your hands on. It's not just the cases that are heard at ICSID and this wealth transferred to the corporations that is the major issue. Regulatory chill and policy-making chill is the major issue, because if you have this huge infrastructure in place, this huge web of economic arrangements whereby multinationals can sue you, it means that it impacts on your thinking when you're devising policies in your country. You would think when a government is deliberating whether to grant an environmental permit, their main priority would be, what impact does this have on our people? But actually, the internal deliberations within the Guatemalan government were about, are we going to get sued by that company if we enact that policy? They eventually gave them the environmental permit. And that happens all over the world, this chill, this policy-making chill. And it's by design. Corporations want to have an insurance mechanism where they can get their profits and get the policies they want in place above the heads of national governments. There are enforcement mechanisms that it's not like you can just say, okay, we're not going to listen to you. If arbitration, if you're called to an arbitration, you don't recognize it, they can start taking your assets internationally. They can. There's a lot of ways of enforcing this system on developing countries. So it's not like somewhere, it's not like domestically where you could just used to be able to nationalize something and then you should pay compensation, but that would be negotiated. This is like this international court will decide and you have to pay, otherwise we'll start stripping you.
So what I mean, you alluded to it there, but what would happen if they didn't pay? So let's say Bolivia takes a mining company owned by the US away from them. The court says, no, you need to, and they're taking it into public ownership, and the court said, this is quite a reasonable one, right? Rather than the case of the Italians in South Africa, which is completely unacceptable, I think. They say, no, you have to give it back to them. And they say, no. They fine them a couple of $100 million. They say, well, we don't recognize this court or this fine. What happens then?
There's actual legal systems in place where they can take your assets internationally. So if you have any kind of government assets in foreign countries, they can be taken. If you have boats in international waters, they can be taken. It becomes a legal matter. But also, you can be massively punished by the Bretton Woods institutions themselves, because ICSID is part of the World Bank, but also so the IMF. They can do really punitive things that mean that you basically can't function. Your credit lines will be pulled. You won't be able to get liquidity if you need it in a time of crisis.